All right, welcome back. Hope everyone had a good week. I'm sorry I wasn't here on Thursday, but I am back now. Questions? Anything in your minds? No? Okay. I want to start today's class with a question, or more precisely, the same question, but at different points of time. And the reason why I want to frame the question like this is to get you thinking about how the Supreme Court's doctrine please be here on time, how the Supreme Court's doctrine has not been a straight line. It's been a bit of a curve. And with a curve, the same question might have different outcomes at different times. So here's your question, right? The question's this. Congress enacts a law to regulate the wages of workers at a coal mine that ships coal across state lines. Congress finds that the moral conditions in the mines are low and that safety conditions are poor. Is this statute constitutional? Everyone get the question, right? All right, so first off, let's just get some general things settled, right? Who was last time? Okay, Katie, you're next? Okay, thank you. Appreciate the honesty. So Katie, what precisely is Congress regulating here?
Wages.
Is Congress regulating the shipment of the coal itself?
No.
Okay, that's an important factor. All right. Please be here on time. Okay. All right. So Katie, let's take this one step at a time, right? Congress is regulating the wages, okay? Let's turn this thing off. Okay? Congress is regulating the wages, right, Katie?
Yes, sir.
Is wages by itself commerce among the states?
No, it's not. It's just local.
Okay. So we're dealing here with not actual commerce among the states, as a boat moving from state A to state B. We're dealing with local activity. And whenever we're regulating local activity, we always have to think of our favorite phrase, the necessary and proper clause, right? You have to keep this in mind, that even though it might seem like Congress is regulating interstate commerce, what they're actually doing here is regulating certain activities that might have an effect on interstate commerce. Okay, so is that Jamie next, or am I going this way?
Yeah.
Jamie, okay, Jamie, let me ask you a question. So I tell you the year is 1842. Okay, I didn't just make up that year out of my head. I picked that year quite deliberately, right? Why do you think I picked the year 1842?
That's the Prigg case.
Prigg, okay? And this is precisely how your exam is going to be structured. I'm going to say the year is 1842, or the year is 1869, or the year is 1903, whatever the year is, right? And your goal is to address the question as if you were alive in that year. If you're in 1842, you know that Prigg was decided. You do not know about the legal tender cases, for example, right? You don't know about the New Deal, hasn't happened yet. So you have to limit yourself to the cases in existence at that time. Everyone with me? Do not, on the exam, please, you will do this. You're going to do it anyway. You're going to ignore me, but I'm telling you this very clearly. On the exam, please don't give me cases decided later in time. You're beating the point of the question. I won't give you credit for it. You can do it. I just won't give you credit. I want you to tell me how the court's approach to whatever issue it is operated in the 1840s. Now, someone asks, well, Josh, what about the month of the year, right? I don't know what month the case was decided. Okay, fine. Just assume December 31st, 1842. Okay, don't. Someone always raises their hand to ask that. I'm not going to kill you like that. I don't give you a month the case was decided. Just assume December 31st, 1942. Okay? All right, so is that Nancy?
Yes.
So Nancy, let's walk through enumerated powers after Prigg, right? How did the court in Prigg interpret the necessary and proper clause? This is a general matter, not specifically, but just generally, how did the court interpret the necessary and proper clause in Prigg?
That when they mention necessary being necessary being.
Very good. That's right. Justice Story relied on McClung v. Maryland and Chief Justice Marshall's opinion. And indeed, in some regards, Prigg went beyond McCulloch. But convenience is a good word, right? So, is that Ben?
Yes.
Okay, Ben, let me ask you a question, right? You were a lawyer for the federal government in 1842, and you have to defend this law, right? What is the argument you would make to the Supreme Court about why Congress can regulate not the shipment of coal, but the wages of the workers in the coal mine? What's your argument?
They would argue that the wages would affect the price of the coal, which affects interstate commerce, and thus is in the power of Congress to regulate that.
Yeah, I think that's right. You would basically argue that so you admit, look, wages are not interstate commerce, but Congress has the power to regulate the shipment of coal among the states. And one of the factors that might affect pricing of the coal could be the local wages, because if one state, has very low wages, that coal is cheaper. And another state which has higher wages will have more expensive coal. That way Congress can regulate, that is, even out the interstate trade market for coal. Ben, that's unreasonable? Right, so then Ben, do you think this law will be valid in 1842? Is it constitutional?
No.
You think it's not? Tell me why.
I think they'd say that it's too far removed.
Okay. That's a fair point. Nick, what do you think? Do you think this law will be valid in 1842?
No, I agree with Ben.
Wow, okay. What do you think, Jonathan?
Yeah.
Why do you say yes?
We're using necessary and proper really broadly. So that way it can regulate interstate commerce.
Yeah, I think Jonathan has a better answer, right? I think when we get to the 1890s, I think the answer might change a little bit, as well as 1869. But if we read Justice Story's opinion broadly, he basically says anything that's legitimate, right? If Congress can pursue some legitimate end, then they can do it, right? Prigg is one of the broadest readings of federal power ever. So I think actually at this juncture, the answer is true. Congress, it would be constitutional. The answer is yes. A. I think the answer would be constitutional. By the way, I'm not doing the poll because I have like 8 of these and it's too messy with 8 poll questions, but I'll have to take it on the honor system that you're doing this in your head. Okay? All right, but thank you for those 3. Okay, so now Dylan, let me ask you this next question, right? We jump to the year 1869, and again, I didn't pull this year out of a hat. Why did I pick 1869?
The DeWitt case.
DeWitt, very good. And what was holding in DeWitt? Do you remember?
That Congress doesn't have the power to prohibit trading from the states.
Yeah.
Of an individual state.
Bingo. That was a case involving oil. Remember in Detroit, the federal government banned the sale of certain types of oil, illuminating oil. And the court said, no, you can't ban the local sale of oils. But wait a minute, Dylan. So you got scared for a second. Dylan, I thought we just said that if there's some sort of local activity and it impacts interstate commerce, Congress can regulate it. How do we explain DeWitt? How do we reconcile DeWitt with Prigg?
Well, in DeWitt, they were completely banning certain types of oil from being sold because they weren't collecting taxes on it.
Yeah, but how do we reconcile the cases? That's an accurate statement of the case, but how do we reconcile Prigg with DeWitt?
Because from DeWitt, because congressional powers may be limited.
Yeah. The court had a different philosophy at that point, right? In Prigg, the court had a very broad reading of federal power, which held the Slave Act, the Fugitive Slave Act. But when you get to DeWitt in 69, you have Chief Justice Salmon Chase, who had a much more narrow vision. Now, look, this is not to say that one's right and one's wrong. You can argue back and forth, but you need to understand there are different philosophies at stake, and different judges have different perspectives on the scope of federal powers. So I think here, in 69, the answer is no. It's false. It would not be constitutional because it's too remote. It's too, you know the word attenuated? It's a word lawyers use. People don't actually know what it means. Attenuated, right? Think of like, you know, remember the game of telephone where you have a can on one side and a can on the other, you put a string in the middle, right? So you're standing close by, it works. If you stand a little bit further away, it gets a little bit, you know, shaky. You're standing really far, it's not going to work, right? As you get further from a signal, it weakens. It gets attenuated. So here, as the local activity becomes more attenuated from interstate commerce, Congress loses authority, it loses power. You have to be closer. Okay? All right. Is that Mitchell? You next? All right. So Mitchell, I gave you this year 1895. Again, I didn't pull this name out of my hat. Why am I using 1895? Why did I use that year in particular? No, 1895. Don't help him. He can do it. By the way, when you put together your outlines, a very useful way of sorting cases is by year. It's not the only way, but in your outline of notes, you should always have very careful notations about the year, because that will allow you to do these sorts of questions. Oh, 1895, I know what case Blackman's talking about. So why did they pick 95?
I'll be sure to add dates from here on out.
That's fine.
Would that be the Knight case?
Yeah, exactly, EC Knight. Okay, remind us what that one was about, please.
The manufacturing and shipment, and it was the manufacturing.
Yes. Was manufacturing commerce?
It depends if there's a direct effect on interstate commerce.
Very good. Very good. EC Knight held that manufacturing comes before commerce, right? Manufacturing, if it has a direct effect on commerce, then Congress can regulate it under necessary and proper clause. If the effect is indirect, an indirect effect, then Congress cannot regulate that commerce under the necessary and proper clause. But please just separate them, right? Commerce is not manufacturing. We all agree on that. But the necessary and proper clause allows Congress to regulate manufacturing with a direct effect on interstate commerce. Let me say that one more time. It's a tongue twister. Congress can regulate manufacturing that has a direct effect on necessary and proper clause through its necessary and proper clause powers. Right? Don't confuse the commerce itself from the effect that activity has on interstate commerce. You have to keep them separate. Most professors confuse the two. Supreme Court justices do it just the same. Okay, so Mitchell, finish it up. In 1895, would this law be valid?
Yes.
You look really uncertain.
I am very uncertain.
Well, what was the holding in EC Knight? Did the court uphold the law in EC Knight?
Yes.
No. No, Amy? What was the holding in EC Knight, Amy?
That it didn't have a direct enough effect.
Very good. That the regulation of the sugar monopoly, the sugar manufacturer, right, was too attenuated, that there wasn't a direct effect in interstate commerce. Therefore, Congress cannot regulate that activity. So, Amy, let me ask you the question again. In 1895, would this coal statute be valid?
No.
Exactly, right? It's too attenuated. There's no direct effect on interstate commerce. Therefore, in 1895, this would be an unconstitutional statute. Isn't it crazy how the exact same question cuts different ways depending what year I ask you? That's the life of ConLaw, right? This is not like, you know, torts or contracts where here's the answer, and this has been the answer for 300 years, right? This is a little different. You have a lot of deviations. Okay, I think, Kyle, I think you're next. So Kyle, the next year I give you is 1903, okay? And again, why do you think I pulled out 1903? Why did I use that year? Very good, the lottery case, okay? And remind us, what was the holding in that case?
The holding in that case was because they were carrying the lottery tickets through traffic from interstate, they were subject to
Yeah, and there was another aspect of the opinion. What did the court think about lotteries in particular that the government had the power to prohibit it? What was like the
moral soul of the country was at stake, so therefore they were doing it for.
Excellent. Perfect. Very good. Yeah. Champion v. Ames was one of those cases where the court said that the federal government has the power to not just regulate, but prohibit the carriage of immoral lotto tickets, right? Because they were immoral, they're like gambling, these sorts of things, right? All right, so Kyle, just finish it up. How do you think this statute would do in 1903 in light of Champion v. Ames as your governing authority?
I think, yeah,
It'd be constitutional.
it'd be constitutional. The moral condition.
Bingo.
That's what they tied directly with those two.
And I put that in there directly for a reason. You have to read the question carefully. I think Kyle just did. This was based on morality as well, that you have low moral conditions in the mines. And I think that this statute would then be valid in 1903. All right, now getting the swing of things, right? All right, so Braden, let me call on you. The next two rely on our readings from today, which I haven't covered yet, but you should have done already, so you should have a guess. Why did I pick 35 for the fifth question? Please, Braden, what happened in 1935?
It was the Schechter Poultry Corp.
Yeah, very good. And just, this case was involving regulation of the local slaughter of chickens, right? So, Braden, how do you think this case shakes out in 35?
I believe it would not be constitutional.
Okay, tell me why.
Because they rely on the EC9.
Yeah. Yeah, so look, you have EC Knight, which says direct effect, indirect effect. Then you have Champion v. Ames, which sort of ignores EC Knight, goes the other way. But then you got 30-something years later, 1935, you got Schechter Poultry. It restores the EC Knight test. I think that's the same answer that Amy gave me a minute ago, right? That the local slaughter of chickens or the local mining of coal does not directly affect interstate commerce. So that's correct, Braden. All right, Kimberly, last one. Finish up the row. Why did I pick 37? What happened in 37?
That's the NLRB Laughlin steel.
Yeah, Randy says Laughlin. I don't know if he's right, but I'll just say Laughlin because I think he's probably right. But yeah, NLRB versus Jones and Laughlin. Ooh, that doesn't sound good. NLRB versus Jones and Laughlin steel. And Kimberly, do you think this statute be valid in 37?
Yes.
Tell me why.
Because that case expands the narrow direct effect test to substantial effects doctrine, which says that Congress can regulate local activity that has a substantial effect on interstate commerce.
Okay, very good. Thank you. That's exactly right. By the time you get to 37, the court adopts what we now know as the substantial effects doctrine, right? You don't need to have a direct effect. Local activity that has a substantial effect on interstate commerce can be regulated by Congress. Damn it. Let's say it one more time. Congress can regulate local activity that has a substantial effect on interstate commerce. What gives Congress that power? The necessary and proper clause. By the time you get to 37, EC Knight's gone, right? The direct effect test is gone. We are basically back to Prig, more or less. All right, everyone get that. So just to summarize, in 1842, the statute's constitutional. In 1869, go away. In 1869, the statute is unconstitutional. In 1895, the statute is unconstitutional. In 1903, the statute is constitutional. In 1935, the statute is unconstitutional. And the last one, 1937, the statute is valid. And preview for next class, 1996. I won't get there yet. We'll get there next week, but that'll be your. I'll delete this. Won't get confused. But we'll do 96 in the next class. Okay. Any questions about that? Yes, sir, Nick.
Yeah. So this fluctuation in decisions, is that like more a product of like the changing of the times, or is it just how different people read and interpret?
It's such a good question, right? I mean, I take your question well because the law students always get frustrated, right? the first day of class, I gave all this beautiful little book. Say, look, we have this Constitution. It's 200 and something years old. It's the oldest Constitution in the United States. And you think, oh, of course, so it's easy, right? But different people with different philosophies read the Constitution in different ways at different times. And I don't think that one judge is a good judge and one judge is a bad judge, or these are judges engaging in politics. I think that judges have philosophies. And some judges have a very broad understanding of what federal power should be, and some judges have a very narrow understanding of what federal power should be. And I think that at different times, different views have predominated. And it's not up to know where we are today, it's to know how we got there. But it's a good question, Nick. And I take your question well. That's a little bit frustrating, to, this little jagged thing. Is that right?
Yes, sir. I just wanted to throw that in there. It's kind of like how pastors or rabbis read scripture.
Yeah.
They make their own, well, not make their own, but they interpret it differently and deliver the message differently. So you have left, right, in this kind.
You got one King James Bible, and how many sermons can be based on it? Yeah, when you have a fairly old text, people have latitude in how they read it. And I don't think one rabbi or one pastor or one judge is smart or an idiot. I think they simply approach it differently. I mean, look, in this class, right, I don't actually care what your politics are. It doesn't actually matter to me at all. I really don't care. But if I were to poll you, you'd have different results. So if you read this way and this that way, not because you're smart or stupid, just people think differently. I think in good faith, people have disagreements. I think that's a good reason why we have law school. We can learn the different perspectives. Now, you need to know what those perspectives are. Whether you agree or not, I actually don't care. It doesn't matter to me, but you need to know what the perspectives are. Okay, any questions so far? All right, I want to show you a brief video. I mentioned this first day of class, but I think people don't read the syllabus. If you go to the syllabus, in the third paragraph, I linked to 2 folders. Let me open them for you, right? The first one is a list of the chapters, right? These are the chapters in the book which will come out, God willing, in 10 days. The bookstore has them on order. It'll be $30. You can get it when it comes out. But for now, you have these PDFs. So, for example, today we did, was it chapter 12 or 13? I can't remember. No, I'm sorry. It was chapter... I'm sorry. Thank you. Yeah, 9, 10, 11. So here's chapter 9, Schechter Poultry, right? It's a short 2-page summary. Some of them are longer. I encourage you to read these. These chapters are very good predictors of what I will ask about in class because I'm not very original. I tend to ask about what I'm interested in. You have to read the cases. This is not a substitute, but this will make you more prepared for class. The second link is for the videos, and some of you may have watched these already. But this is a folder with the videos we produce for every class. Again, these will be on the Casebook Connect when you buy the book, but they're there for now. Even if you can't watch the YouTube lectures from last year, I'd encourage you to watch these short videos. They will make your life a lot easier. And I want to show a brief clip now. This is actually a video you haven't seen yet, but it's a video that you should watch soon. And the reason why is it gives a brief history of implied powers. Okay. Here, I'll just play from the beginning.
United States versus Motel, 1995. Though the words of the commerce and necessary and proper clauses remained constant over the past 2 centuries, the Supreme Court's interpretation of their reach has not. The court's interpretation of the scope of commerce among the several states has not much changed since the founding. To this day, it still is largely confined to trade and transportation of people and things from one state to another, though one outlier decision from 1944 held that commerce includes insurance. However, the court's construction of Congress's implied powers to reach activity beyond interstate commerce has fluctuated greatly. Join me on a brief history of implied congressional powers.
Okay, so hold on. I'll just show you this scene first. Go back.
However, the court's on a brief history of implied congressional.
All right. I actually want to get full screen so it's easier to see. This was, I think, Nick's question a minute ago, right? What this graph attempts to do, whether it does it well as I'll leave it to you to decide, but what we tried to do was to graphically represent how the court's approaches to implied powers have fluctuated. Now, this is not commerce. The word commerce has had the same meaning, the movement of goods and trade. That's the same meaning it's had since Gibbons. But what's fluctuated is the court's necessary and proper clause case law, right? So we start over here. It's hard to read, but you can see on your screen with the Marshall Court, right? Actually, here I have it's high resolution over here. There we go. Okay. So you start with the Marshall Court, the Tawney Court, the Chase Court, the Progressive Court, and the New Deal Court, and the Warren Court. We identify the court based on the Chief Justice who was in charge. We've only had about 17 Chief Justices, give or take. So it's a general era. We don't do all the Chief Justices. Most of them were not very important, but some of them were fairly significant. So we start with the Marshall Court. You have McClung and Gibbons, right? And then we go to the Tawney Court. You see Prigg had a very broad reading of federal power that was needed to uphold the Fugitive Slave Act. Then we go to the Chase Court, Chief Justice Salmon Chase. He had cases like DeWitt and Hepburn, which were very narrow readings of federal power. But then you have Knox, the legal tender case, in which there was a very broad reading. In the progressive era, E.C. Knight had a very narrow one. You have Champion, Hammer, and we'll get to Schechter, Poultry as well. Once we get to the New Deal, you'll see that things start cropping up very quickly. In the heart of Atlanta and Katzenbach go up even higher. For the next class, we'll do the Rehnquist and the Roberts courts eventually. It goes even higher. So the general idea is since E.C. Knight, it's been a gradual uphill climb. It hasn't been straight up, but it's been a gradual uphill climb. Sometimes it plateaus. NFIB, for example, didn't go higher than Raich. We'll get there later. Okay, let me just play a minute of this video, and then I'll go on to today's class.
First, in the earliest days of the Republic, President Washington determined that Congress had the implied power to create the first bank of the United States, over the objection of James Madison and Thomas Jefferson. Second, during his term as Chief Justice, John Marshall continued the broader Hamiltonian reading of implied federal powers in cases like McCulloch and Gibbons. Third, we studied the case of Prigg, decided during the Tawney Court, which applied an even broader construction of the necessary and proper clause to find an implied power to enforce the Fugitive Slave Clause. Fourth, in DeWitt and Hepburn, Chief Justice Chase narrowed the approach to Congress's implied powers, but then in Knox, following the appointment of new justices by President Grant, the court adopted perhaps its broadest description of the scope of Congress's implied powers. Fifth, during the progressive era, the court flip-flopped. In E.C. Knight and Hammer, the court narrowed Congress's implied powers to regulate local business transactions, but in Champion, it permitted the prohibition of the sale of lottery tickets. Then, in Schechter Poultry, it reasserted a limit on Congress's implied powers and invalidated the National Recovery Act. Sixth, the New Deal Court in Darby ushered in a radical redefinition of implied federal powers by adopting the substantial effects test, which was then expanded further by the Aggregation Principle adopted in Wickard. Seventh, these New Deal doctrines governing implied powers then continued on to the Warren Court and were used to uphold the Civil Rights Act of 1964 in Heart of Atlanta and in Katzenbach, where the court added a jurisdictional hook to regulate interstate activity that used items that had traveled in interstate commerce.
Okay, this is as far as you've gotten, but it's a helpful way to understand the chronology, the timeline of these cases, which are not easy. But in this class, unfortunately, you need to know cases and you need to know the years. Now, I don't expect you to memorize the exact year, but the decade's helpful, right? Well, New Deal is 1930s, Warren Court's 1960s. You should have a general sense of when cases occurred. You can always check your notes, the exam's open book, but you have to have a general idea of when things happened, at least in sequence. Make sense? Good? All right, any questions so far? Okay, let's start today's class with our first case. Fosa, you want to give me the facts, please, in Schechter Poultry Corporation versus United States?
So the defendant was indicted on 18 counts, one conspiracy, 2 violations of minimum wage, and 10 a violation of the state minimum requirement.
Okay, so just take a step back, right? What law was at issue here? What was the law that was at issue here? What was the name of the law? That was the regulation. What was the name of the law? Okay, those are the regulations. What was the actual law that Congress enacted that was at issue here? We're getting there.
Oh, National Industrial Recovery Act?
Yes, the National Industrial Recovery Act, or NRA for short. It's not NIRA, it's just NRA. I couldn't tell you why, but that's what it's called. The National Industrial Recovery Act, with NRA for short. Okay, folks, so what did the NRA do? We'll get to the Poultry Code in a minute, but what did the NRA do?
Approved codes for fair competition.
Did Congress approve the codes for fair competition?
Yes, that's the section.
Did Congress approve of the Poultry Labor Code?
The president did that.
Ah, what did Congress do then?
As in from the opinion?
What did the law actually do, right? Specifically, what did the law accomplish? The president approved. Go ahead.
It regulated the hours in the week.
But did Congress specify what those regulations are?
No.
No. Okay. Very good. Here's the key fact. The National Industrial Recovery Act, the NRA, authorized the president the power to approve codes of fair competition. Again, Congress didn't actually create those regulations. Congress empowered the president to authorize those codes. Everyone with me? Michael, what's maybe a little problematic about the idea of Congress giving the president the power to approve codes of labor? Why is that maybe a little problematic as a general matter? Forget chickens for a minute. As a general matter, why is this problematic?
You could do it to further himself.
Okay. But why is it problematic when Congress allows the president to enact laws of competition? Why is that problematic?
They could do it whether it affects the interstate commerce or not.
Okay, that's absolutely true. But generally, what kind of powers does the president have?
Executive powers.
Okay, and what kind of powers does Congress have?
Legislative.
Very good. So what's problematic when Congress allows the president to enact codes of competition?
It must give him legislative powers.
Bingo. Thank you. Perfect. The Schechter Poultry case is significant for a lot of reasons. But one of the reasons why is the court recognized that this is problematic. Congress gave the president a blank check to basically enact laws, right? Congress gave the president the power to enact just about any law he wanted to regulate local labor conditions. Congress wasn't regulating the local labor conditions. Congress gave the president the power to regulate local labor conditions. We say that Congress delegated, right? Congress delegated to the president legislative powers, right? Congress delegated to the president legislative powers. Does Congress have the power to delegate legislative powers? The answer is pretty much no, but with some caveats. This case employed what would be called the non-delegation doctrine. The non-delegation doctrine. This doctrine basically says that Congress cannot give up its legislative powers to the executive branch. Congress cannot give its legislative powers to the executive branch. Right? Congress can't tell the president, you know what, we don't want to make laws anymore, you go make the law. Right? No, it's for Congress to make the laws. Now, this might sound like a very simple, obvious principle. But it doesn't have much teeth today, or at least at the moment. Schechter Poultry was 1935, and in 1935 the court had two big cases where they said that Congress cannot delegate legislative powers. 1935. We are now, what, 85 years later? The court has never again since said that this non-delegation doctrine was violated, right? We have these two violations in 1935. It was a good year for the non-delegation doctrine, to quote Cass Sunstein, but it's been pretty bad since then, right? So since 35, the court has basically said, never mind. And they've approved of these sort of delegations of authority. Now, why am I stressing this? Because I think that case law is about to take a turn to the right, shall I say. In a decision decided last term, 3 justices, and probably more, suggested they were looking to revisit the non-delegation doctrine. So this is a case, a doctrine you should probably be familiar with, I think at least. But that was an important part of Schechter Poultry, that Congress cannot give the president basically a blank check to make whatever laws he wants. Okay, everyone with me? But that's not why the case is in your book primarily, right? The reason why the case is in your book is how Schechter Poultry fits in with the Commerce Clause and the Necessary and Proper Clause regulations. So Designate? I said it right? Good. So Designate, let me ask you this question. What was the actual activity that the government was trying to regulate here for the Schechter company?
They were trying to regulate the environment of the, not the environment,
Well, sorry, what was their business? What business were the Schechters in?
okay, they were into slaughtering chickens.
Butchers, okay, very good. Where do they get their chickens from?
They got them from out of state.
Okay, very good. And then where was the slaughtering taking place?
In state, in New York.
In Brooklyn, okay, good. And where were their sales being made? Where were they selling?
Sales were like within the state.
Local.
Local.
Okay, very good. Thank you, ma'am. We have here a situation where the Schechter brothers, the Schechter Poultry Company, were importing chickens from out of state, slaughtering them locally, and then selling them locally. Okay? Now, is that Ray? Was Congress, or I should say, was the executive branch regulating the shipment of chickens between two states?
No.
What exactly was Congress regulating here? What was the precise regulation at issue?
The killing and selling.
Very good. This is like the coal mine question I asked before, right? The government was not regulating the shipment across state lines of the chickens. Instead, they were regulating the conditions in which they were slaughtered, the labor conditions, how much the wages are being paid, and how customers could actually purchase the chickens. Everyone with me? Okay. Now, a little background which is relevant. The Schechter brothers were kosher butchers, and you may or may not know this, but a kosher is a type of ritual slaughter. And there are many different ways of slaughtering chickens. One of them is kosher. For example, when you kill the chicken, you have to have a very sharp blade to slice the neck so it doesn't feel any pain. These are fairly old rules. And there are different ways of following the rules of kosher. One of them is to make sure the chickens aren't sick. Back then, there were no antibiotics. So very often chickens had tuberculosis, right? We think, oh, we don't want these chickens pumped up with antibiotics. Okay, that's great. But when you don't have that, chickens had TB. You get very sick with them. So very often people would go to the butcher shop and they would check the bird, see, is this bird sick? In fact, this case is called the sick chicken case. That's what it's called. In the Jewish communities, there was a specific rule that says you couldn't sell or buy sick chickens to another Jew. It was not permitted. Okay. One of the regulations that the Roosevelt administration enacted was called the straight killing rule. What was straight killing? You had to buy a coop of chickens, basically a grouping of chickens all together. You couldn't pick and choose, oh, I want this bird, and I want this bird, I want this bird, right? You had to pick whatever was given to you in that coop, you had to take it. Why was this rule enacted? To decrease choice, right? To make it easier for vendors to sell, right? Everyone was in the same playing field. You sold whatever you got. You bought whatever you got. This made it tough for some customers who followed the rules of kosher. They didn't want the sick chickens. They didn't want to buy the entire coop. The government also regulated the wages being paid to the butchers that had a minimum wage. The government prosecuted the Schechter brothers. By the way, in Yiddish, it's a Germanic Jewish language. The word shecht means actually slaughter. So their name actually was a slaughterer. That was their, that was their last name. Imagine like their last name was butcher. Their last name was like the butchers. So the government prosecuted them. And the Schechters argued that the prosecution was unlawful because the National Industrial Recovery Act didn't reach their conduct, right? Congress could not regulate this local activity. All right, with me so far. Okay, so Sergio, walk me through the court's opinion. What did the court hold here?
That Congress can't give legislative power to the executive.
Okay, that's number one, right? That the statute violates the non-delegation doctrine. But Sergio, could Congress in its own right regulate the local slaughtering of chickens in Brooklyn?
No.
Okay, tell me why.
Basically, applying EC 90 that it was in the act of an activity, I guess.
Okay, very good. The court here in Schechter Poultry, 1935, files EC Knight. And the court finds that there's no direct effect between the local sale of chickens and the interstate chicken market. Right? That this local transaction is too remote from interstate commerce. Right? Even though the birds come from out of state, the act that's being regulated is not the transportation of the birds. The act that's being regulated is their slaughter and their sale of the carcasses. Okay? Everyone with me? But wait a minute. Is that Richie? Richie, but doesn't the local sale of chickens affect the price in other states? If I can buy really cheap chickens in Brooklyn, I won't go to New Jersey to buy chickens. I mean, can't Congress regulate local activity that might burden interstate commerce? Isn't that within Congress's powers?
They said that usually, I guess the court held that any business places that attempt to interfere with Congress power regulation laws or have affect the free market were in breach of the Antitrust Act, but because this was not the case here, specific, that they were regulating something that was local.
Okay. Yeah, very good. Here, Congress was trying to regulate what was local, right? And it was up to the states to control the sale of chickens and their slaughter. It was not for Congress to do this. Okay? Right? The court says there's still a distinction between what the states regulate and what Congress regulates. Once you let the federal government regulate X, the states can't do it anymore, right? When you say that the federal government can do X, that power is removed from the police power of the states, right? The states can no longer engage in that activity. And that there are some matters that are solely for the local governments to control. Okay, everyone with me? Okay, the holding in the holding in Schechter Poultry was that the NRA was unconstitutional, and the court reaffirmed the EC Knight. Schechter Poultry was unanimous, and it was joined by some fairly progressive justices who were otherwise in favor of federal power, but they thought this law just simply went too far. Okay, everyone with me? All right, what happens next? Well, what happens next is the stuff of legends, so to speak. That's it. I'm being dramatic. But it is an important story, which all law students should know, and they should know the correct version of the story also. So we have, let's go back to our map, our timeline. Right? So we have EC Knight, we have Champion v. Ames, we have Hammer versus Dagenhart, we have Schechter, which all had a fairly flat reading of federal power. But then we get to Franklin Roosevelt, right? We get to the New Deal. What happened here? Most law students, I shouldn't say most, but many law students are told a story. The story is not accurate, but here's a story they're told. President Roosevelt was elected in 1932, and his platform, his promise was to use the power of government to bring the United States out of the Great Depression, right? To use federal power to improve labor conditions, to reduce shortages of food, to improve prosperity, to make America great again, I don't know, right? To use government to help people out. The story goes like this. The Supreme Court, though, was still conservative. And the Supreme Court would just stop everything Roosevelt was trying to do. And then Roosevelt said, aha, I have an idea. If the Supreme Court won't give me what I want, I will change the Supreme Court. And then Roosevelt proposed the famous court packing scheme to add new justices to the Supreme Court and also judges to the lower courts. And these new judges would be sympathetic to his administration, sympathetic to progressive laws, and would uphold everything. Now, the mere threat of this court packing plan made the Supreme Court change course. And there was one justice, his name was Owen Roberts. He's not related to Chief Justice Roberts, but same last name. And Justice Owen Roberts said, oh no, we can't have this court packing plan. Now I will start to vote in favor of the federal government. It sounds like a fairy tale, and it's not true. I was taught that, and it's simply not accurate. How do we know this is not accurate? Because we have records, which suggest that justices did not change their vote in response to this court packing plan. Instead, what actually happened, we had different justices appointed to the court with different ideology. In the early 1930s, President Hoover, Herbert Hoover, right, was a Republican, but he was a progressive. And he appointed two justices to the court who were progressives. He appointed Justice Owen Roberts and Chief Justice Hughes. All right? And those justices would generally be progressive, although sometimes Roberts flipped back and forth. All right? Then we get to 1937, right? And what happened? The court decides a case called West Coast Hotel v. Parrish. West Coast Hotel v. Parrish, P-A-R-R-I-S-H. We'll do this case later in the semester, but I'll give you a preview now. West Coast Hotel v. Parrish concerned the minimum wage, right? Could a state enact a minimum wage? And in the past, the court held that Congress could not enact the minimum wage, right? It wasn't for the federal government to have this power. But the court changed direction in in West Coast Hotel. And Justice Owen Roberts said, yep, minimum wage laws are fine. Now, here comes the fun part about timing. Roberts had voted a year earlier to halt the minimum wage law in 36. But in 37, he upheld it. Did Roberts change his vote based on the Roosevelt court packing plan? No, he didn't. Right? The difference was because the cases were litigated differently. In the West Coast Hotel case, they asked to overrule some old precedents, which Roberts did. All right? But the upshot is, by the time you get to 37, Roberts had changed his mind. We had this court packing plan, which was defeated. But the court changed course. The court was no longer going to insist upon showing a direct effect, right? Now Congress could regulate local activity that had a substantial effect on interstate commerce, right? That is NLRB and Jones and Laughlin Seal and Darby. And then we get to the third case, which is Wickard versus Filburn. And Wickard builds upon this substantial effects doctrine with what's called the Aggregation Principle. So you have local activity, seems pretty insignificant, growing of wheat. You can aggregate all the local farmers nationwide, add them together. And if that local activity has a substantial effect in interstate commerce, then Congress can regulate it. And let me tell you something. Once you get to Wickard, there's very little Congress cannot do. Once you get to Wickard, almost the entirety of human activity is within the scope of congressional regulation. Perhaps not inactivity, as we'll see next week, but all activity, at least, is within that scope. All right, questions so far? All right, let's start with NLRB. Matt, you want to give me the facts, please, in NLRB versus Jones and Laughlin Steel?
Sure. In 1935, Congress passed the National Labor Relations Act.
National Labor, yeah. Okay.
Yes,
Good.
National Labor Relations Act, which sought to regulate, enforce federal fair labor practice standards, which included the right to organize in unions.
Okay.
The Jones and Laughlin Steel Corporation had fired some group of employees who were trying to organize a union.
Yeah.
And the National Labor Relations Board enforced an action for that.
Okay, very good. Thank you, Matt. The National Labor Relations Act was one of the most significant New Deal laws. And this law gave the federal government the power to regulate local labor conditions that affected interstate commerce. So for example, here you had a firm, the Jones and Laughlin Steel Company, which prevented unions from forming. They basically fired people who were trying to organize collective action. Okay? What happens? The steel company says, no, you can't regulate me because we are local, right? It's true we ship steel out of state, no doubt about that, but the thing you're regulating is our labor conditions, which are purely local. Our workers are in one state. Come back down to Hanna. So Hanna, what did the court hold in Jones and Laughlin Steel?
The act was a proper exercise of Congress's power to regulate interstate commerce.
Okay. Was the opinion premised only on the Commerce Clause?
I also have that employees have a right to self-organization, and then the court further ruled that interstate activities that are closely connected to interstate commerce were subject to regulation.
Okay, I'll ask the question again. Was the court's opinion limited to the Commerce Clause? Ethan?
Yes, sir.
Okay, so what else was the court's opinion based on?
The necessary clause.
How do we know that?
Because they relied on stuff outside of the enumerated powers.
Does the court even mention the necessary and proper clause in the opinion?
No, sir.
How do you know then? What's the tell? What's your hint?
Based on the fact that it's not enumerated, that the power to
What word is the giveaway that they're relying on necessary and proper? It's my little cheat, my little hint to you. It's a word. Yeah?
Was it the, I think because they started talking about substantial effects?
Effects. That's the magic word, right? When you see a question or a fact or a case that talks about effects, and it's unfortunately it's effects with an A or effects with an E. They something to do with both ways, depending if it's the noun or the verb. But effects, right? When you see the word effects, you got to think necessary and proper, right? Everyone agrees that what's being regulated here is not interstate commerce. Instead, what's being regulated is local activity that has an effect on interstate commerce. Okay? Now, what changes from EC Knight to NLRB is how strong that effect has to be. In EC Knight, the local activity has to have a direct effect on interstate commerce, a direct effect, right? It directly affects interstate commerce. In NLRB, however, the court modifies that test. The test is no longer whether the effect is direct. The test is, does the local activity have a substantial effect in interstate commerce? Everyone see the difference? You go from a direct effect, which is a very close link, a very tight fit, to a substantial effect, which like, well, you know, is there some sort of general impact of this activity in interstate commerce? So consider it, right? Does Jones and Laughlin's anti-union behavior directly affect interstate commerce? Not really, right? Doesn't really affect prices that much. But is there a substantial effect? Yeah. Right? If he fires 100 workers and all those workers, you know, are unemployed now and he pays lower wages, yeah, that probably impacts the labor market, and that probably impacts wages in other states, and that might impact how much their steel costs. By shifting from direct effect in EC Knight to substantial effect in NLRB, the court broadened the scope of activities, of economic activities, that Congress can now regulate, right? This was the big shift from EC Knight and Schechter to Jones and Laughlin Steel. Okay? Everyone with me? Okay. Jones and Laughlin Steel was a huge opinion, right? But even the court in Jones and Laughlin Steel recognized that there has to be a limit, right? This is what we call a limiting principle. What's a limiting principle? It's kind of like an exception, right? You say, well, Congress has all this power, but they can't do that. You know, I would do anything for love, but I will not do that, right? There's something that Congress just cannot do, right? Some of you got that, okay. There's some things that Congress can't do, and they drew a line somewhere. And where's that line? They say, we cannot destroy the distinction, right, between commerce among the states and the eternal concerns of a state. We cannot destroy the distinction between what is national and what is local. In other words, we know what we're doing here is very risky, right? We're giving Congress a lot of power, but don't worry, they can't do everything, right? There's still some stuff for the local states. What is that? We won't tell you, and we're not really going to make a clear line, but there's still some stuff, right? There's still some local concerns that are not for Congress, right? The court writes, we cannot obliterate the distinction between what is national and what is local and create a completely centralized government, right? We cannot create a completely centralized government. This is the so-called limiting principle that the court is very stringent upon maintaining because they recognize if they just go ahead and say, screw it, Congress, whatever you want, then the entire idea that there's some things the states can do is gone, right? Because whatever Congress can do, the states cannot do. That's by virtue of federal power, the supremacy clause. If Congress regulates X, the states cannot regulate X, right? Let's say the state doesn't want to have labor unions. Too bad. They got to have them now, right? Let's say the state wants to have a lower minimum wage to ensure people have access to labor markets. They can't do it now, right? Let's say the state wants to ensure that kosher butchers have access to whatever chickens they want. They can't do that now with the NRA was in power. So they limit it, but the limiting principle is not very satisfying because it doesn't really tell you what is local. Okay. Questions on NLRB. NLRB versus Jones and Laughlin Steel. Questions on NLRB versus Jones and Laughlin Steel. Okay. All right, let's go into the next case, which is Darby. I think Tanner, Matthew, you're next. You want to give me the facts, please, in Darby?
Yeah, so in 1938, Congress passed the Fair Labor Standards Act.
Very good.
To prevent the introduction and shipment of goods produced under labor conditions that failed to meet
Yeah, just I like how you frame that, right? It's to prevent the introduction of goods into the interstate market from, say it again, I like how you framed it.
Prevent the introduction and shipment of goods produced under labor conditions that fail to meet federal standards.
Okay, yeah, let me stop you there. Okay, everyone see what he just said. I think you recited the facts very, very well, right? The purpose of the law was to regulate interstate commerce. But the actual thing being regulated was not the lumber, the shipment, the good itself, but what was being regulated was local wages, right? Basically minimum wage. All right, so here again, Congress was regulating local minimum wages based on its power to prevent certain inferior goods from being put in the marketplace. And that doesn't mean that the goods were like poor quality or that they're going to fall apart or whatever. It just meant that they were made with labor conditions that Congress found improper. Okay? So we have this minimum wage, and then we have workers then who work for, I think it was in South Carolina, who challenged the minimum wage law. All right, so Tanner, what's the holding here in Darby?
That it is constitutional.
Okay. What about E.C. Knight and Hammer versus Dagenhart and these other cases? What about all those other doctrines?
It is essentially gone.
Yeah.
I said that it has been completely overruled. So
Yeah.
go to a bye-bye.
I'm sorry? They go bye-bye, is that what you said?
No.
What'd you say?
No, they aren't going to abide by anymore.
Oh, they aren't going to abide by. I heard bye-bye. They want to say bye-bye? I heard bye-bye. I mean, either would be correct. They say bye-bye-bye to E.C. Knight. Yeah. Yeah. See you later. They will not abide by. Well, that's good. Okay. They will not abide by E.C. Knight and Hammer. They overrule those cases. They expressly overrule Hammer in particular, because if you recall, Hammer was about the prohibition on child labor, right? They said, well, you can't regulate the shipment of these goods because you're really trying to regulate local labor conditions. Here, that's gone. So by the time you get to U.S. v. Darby, it was in 41. What year was Darby? 41, yeah, thanks. I generally know the cases, but not always. Okay. Yeah, so by the time you get to Darby in 41, the court had more Roosevelt appointees, and they were okay with saying, you know what, we're just going to say bye-bye to these old cases. It works. Say bye-bye to these old cases and overrule Hammer versus Dagenhart. I don't think they expressly overrule E.C. Knight, but this kills the direct effect test, right? At this point, the substantial effects test is now settled law. Okay? And they're not particularly concerned with invading local concerns. That, the limiting principle, they don't really even mention here. It's like, all right, whatever. Federal government will take care of these problems, and we're not going to be in the business of telling Congress no. What about the 10th Amendment, right? The court reads the 10th Amendment in a very narrow fashion towards the end, right? They say all it does is it, describes who has power. Either the states have the power or the federal government has the power. It doesn't ensure that the states have any right to regulate their own people. It's beyond the scope. As a result, in Darby, the court gives Congress a lot of power to regulate a huge chunk of human activity. Not everything, but a lot. Okay, any questions on U.S. v. Darby? Okie doke. The next case was a different story altogether. 1942, Wickard versus Filburn. The reason why this case was so controversial is it went beyond Darby, right? Darby said, yeah, we have this activity which substantially affects interstate commerce because they're shipping stuff, right? They're making lumber, and that stuff is later being shipped into interstate commerce. So of course the conditions of those workers are going to affect interstate commerce. But the next case is a little bit different. Is it Natalia?
Yes.
What were the facts in our next case, Wickard versus Filburn, 1942?
Well, I think the Agricultural Adjustment Act of 1938 made it that if you grew more
wheat crop than allowed, you would have to pay a quota.
Very good.
And so this farmer.
Wait, so just if you grew more than your quota, you pay a fine.
Yes.
Yeah. So the quota was the limit, but yeah, you're right.
Yes.
Go on.
And so this farmer, for his personal use on his farm to feed his livestock, he grew more than he was allowed to, and he got fined. And so he sued Wickard.
Yeah, Wickard was the Secretary of the Agriculture.
Yeah, he sued him because he said, well, it was unconstitutional because it did not relate to interstate commerce.
Okay, very good. Thank you. Okay, thank you, Natalia. Wickard was a different case because we weren't dealing here with a manufacturing firm that shipped their that shipped their goods out of state. We were dealing with a farmer, right? Who, in this case at least, was growing wheat on his farm. He says for use by his own family and use by his own livestock. Now, God bless. I'm from New York. These numbers mean absolutely nothing to me, but invariably I have a lovely Texan who knows what this means. He harvested 239 bushels of wheat in excess of his quota. Anyone? I know the answer, but is this a number that one could use by himself? Mitchell, you're shaking your head no?
That just sounds like a lot of wheat.
I mean, what the hell's a bushel? I don't even know. What's a bushel? It's just 60 pounds of wheat. Okay, so 60 pounds. So we're talking like, is that right?
Yeah.
Thank you. That's a good answer. So we're talking like over 1,000 pounds of wheat. And like how much wheat could a family and a farm consume in a period of time? Does that sound even remotely reasonable?
Himself and his family, no, but maybe the cattle, livestock, possibly.
Okay. Anyone else want to add anything? There's people nodding there. It's usually the Aggies chime in. God bless them, right? The facts are almost exactly as Nolan and Mitchell suggested. He was selling this wheat in the black market, right? We're like, I mean, we're fairly certain this was going on. The facts in this case were, how should I say, in dispute. And usually the Supreme Court, when they have a case with like facts which aren't clear, they send it back down to the lower court and say, okay, we're not going to deal with this stuff. But they needed this case because on paper, at least, the facts were perfect, right? On paper, at least, it was, oh, this guy is just growing some extra, a couple, a stalk of wheat, what do you call it?
Well, a bushel is just a measurement.
Okay. What do you call the wheat in the ground? You call it a
Wheat.
Okay.
I think it's a plant.
A plant. Okay. So you're growing a couple extra plants of wheat, whatever you want to call it, right? And can Congress go ahead and tell you how much you can regulate? Okay. So that's why this case was so good. And the system they erected was pretty insane. The federal government paid farmers not to grow extra wheat. The government was trying to restrict the quantity of wheat. Why? Well, the economics are beyond my expertise, but the general notion is if we restrict the supply of wheat, we raise the prices of farmers. So they would punish farmers who grew too much, who were trying to saturate the market with wheat. Now keep in mind this was during the Depression and people were hungry, but whatever, right? This was a new deal, right? Bold experiments have to be tried. If they don't work, we try something else. The government basically went after Filburn, who was a farmer in Ohio. By the way, he later changed his name to Filburn, B-R-U-N. I think there's a typo in the book that says Filburn, but it should be Filburn. And totally random story. I gave a talk on this case about a year ago, and the guy says, "Oh yeah, my name is Filburn." I was like, "I wonder if I'm related." Like, it's the same name, and they actually were related. Like, he always thought it wasn't, but he changed his name to Filburn. Anyway, the government came after him. This case was controversial. It was actually re-argued because initially the court was willing to say that Congress can regulate whatever it wants, right? Whether the effect is direct, whether the effect is substantial, or the effect is insubstantial, right? Congress can regulate any local activity. The court would not go along with that broad reading. They were uncomfortable with it. So instead we have an opinion by Justice Robert Jackson, a very famous justice, where the court does something else, right? David, walk me through Justice Jackson's analysis in Wickard against Filburn.
Basically that even if the wheat that he grew himself
aggregate, it would have a substantial effect on commerce?
Yeah, very good. So here's the idea, right? Let's say you have, one farmer growing wheat on his farm, local wheat. Is this actually what wheat looks like? I hope it's close enough. Okay, I had to Google this stuff and I had a leap of faith. Okay. If one farmer grows wheat on his farm, it's no big deal, right? If maybe 2 farmers grow wheat, if 3 farmers grow wheat, right? But if we aggregate all the local farmers nationwide who are growing their local wheat and not putting it on the market, right? It has a substantial effect on interstate commerce. Why? Well, what happens if Filburn didn't grow this extra wheat? Would he just stop eating? No, he'd have to buy it, right? What happens if Filburn didn't grow this wheat? Would his animals starve to death? No, he would buy from somewhere else. By using your locally grown wheat, you are no longer going to the marketplace. And because you're no longer going to the marketplace, you are now distorting the prices, right? Right? You're not going to the market to get the market price wheat. You're getting it below market, and you're distorting the interstate marketplace. This is what we call the aggregation principle, which is then sort of put on top of the substantial effects test, where even if the individual person's business does not have a substantial effect, you can aggregate all the other businesses in the same effect. Now, here's the key. Do we know how many farmers there were like Mr. Filburn? We have no idea. Is there like some sort of a census of farmers, growing their own product? No, we have no idea. But under the aggregation principle, we can imagine, right? We can say, let's assume, right? Assuming arguendo, which lessons love, right? The assuming arguendo, right? Well, let's just assume that's the case. Is there evidence that Congress was concerned about this problem? Absolutely not. But we'll assume, right? Could Congress have rationally concluded that this is a problem? If the answer is yes, then the law is valid. Could Congress have rationally concluded that locally grown wheat has, in the aggregate, a substantial effect on interstate commerce? The answer is yes, then the law is valid. There does not need to be proof or evidence that Congress actually thought this, or actually Congress even cared about this. The courts can come in after the fact and simply provide this assumption as a basis to uphold the law. And that's what Wickard did, right? Wickard basically said, there's no need for proof, there's no need for facts, we'll just assume, we'll just rationalize it. And we can rationalize it, then Congress can do it. And because some of the wheat may ultimately make it to the marketplace, good enough for us. Once you put substantial effects on top of the aggregation principle, right, almost every single activity that's local in nature might, in the aggregate, have a substantial effect on interstate commerce. And then Congress can then regulate and even prohibit that local activity. Okay. Questions on Wickard? Yes, sir, Mitchell.
From where we started in the necessary and proper, it seems like we've gotten quite a few steps to get to the aggregation principle.
Yeah.
So, would you say this is just like we're now starting to get to the very broad, very, basically making up things to apply the Constitution?
Well, again, I don't want to use the word making up. I think I understand where you're coming from. I wouldn't use that phrase. But I think what the court did in Wickard was they effectively said, we're not going to scrutinize federal legislation. If Congress has the votes to enact this, and Congress thinks it's a serious problem, we're going to defer to Congress about what their powers are. And really, it's not new, right? Prigg Prigg did much the same. Justice Story said if Congress is pursuing a rational, legitimate end, it's not for the court to second guess it, right? If a law made it through the political process, the president signs it, right? Who are we as judges to say that that's not within Congress's powers? Now, other judges, E.C. Knight said, of course it's our power, right? So it's how much deference should a court give to Congress's determinations about what is valid? Even with the Bank of the United States, remember that James Madison signed it the second go-around. He thought, okay, Congress thought it was necessary. It's not my question. Yes, sir?
So in this case, the Supreme Court kind of giving away a part of its power for like something like judicial review?
Well, by the time you get to 1942 with Wickard, virtually the entire court had been appointed by Roosevelt. Right? Roosevelt would ultimately make 9 appointments to the Supreme Court. So there were no more conservatives left at this point to say otherwise. But in many regards, Wickard did, I'd say surrender, maybe a different word, but Wickard said courts will no longer be in the business of demanding Congress to justify its laws, right? That if there's some rational basis on which Congress could regulate local wheat, then that's good enough for us, right? We're not going to scrutinize it. It goes even a little bit higher in our next cases, the Atlanta and the Katzenbach case. But we'll see in the 1930s and 40s, the court basically got out of the business of scrutinizing federal laws. That will change in the 1960s, and they start scrutinizing other laws. But at least for federal power, the New Deal is like, we want to be restrained, we want to be reserved, we're not going to be bold. I hate the word activist, it doesn't mean anything. But we don't want to be in the business of telling Congress no. That if Congress finds it's within their power to do something, it's not for us to second guess. Yes, but without question, the New Deal was about getting the courts out of public affairs, right? That if a law had popular support, that was enough. Yes, sir. Nolan.
So the new test for what affects interstate commerce after this case wasn't just substantial effects.
Yeah.
But it's the effects plus the aggregation.
Yeah, and again, you're not going to see in a court decision, oh, we use substantial effects plus aggregation principle. Like, that's not like, they don't use those words, but that's my way of describing to you what they're doing, right? The court's always very, what's the right word? Cloudy about what they're actually doing. They don't say it directly, but I think these two phrases help to explain it. And again, they won't say this in an opinion, but you can sort of use language to describe it. But the substantial effects test is without question the controlling doctrine here. But the shift with Wickard is that they say it's not only one farmer's bushel of wheat, it's all the farmers nationwide. And once you start aggregating, there's really not much of a limit. There is a limit, we'll get there, but there's not much of a limit. We'll get to another limit. We do the Ollie's barbecue case in a few minutes. Okay. So any questions on Wickard against Filburn? Very important case. Very important case. And whenever I talk about this case to non-lawyers, they're always very confused. They say, "Wait a minute." Like, if a non-lawyer says, "So Congress can regulate interstate commerce. How on earth is locally grown wheat interstate commerce?" Right? Just how does that even make sense? Which is why you need to bring necessary and proper. That's what bridges the gap, so to speak. Okay. Other questions on Wickard? All right, so let's fast forward about 20 years or so. And we go forward to 2 cases decided during the New Deal. I'm sorry, during the Warren Court. Now, who the hell's a Warren Court? Okay. In the 1950s, I think 1952, might be off in the year a little bit, but in 1952, President Eisenhower appointed Chief Justice Earl Warren, probably one of the most significant Chief Justices of all time. He's up there with Marshall. The Warren Court sort of took a turn from the New Deal Court. The New Deal Court was defined by what we might call deference, right, where the courts defer to the elected branches, that if Congress or the states want to do something, the courts will not get in their way. That was a sort of philosophy of the New Deal court. The Warren court had a different perspective in that they were very concerned about civil rights. The most famous decision that they rendered was the Brown versus Board of Education, which we'll do in a couple weeks, which involves school desegregation, right? There were lots of cases involving bans on interracial marriage, bans on segregated facilities, right? These were sorts of cases where the court found that state laws were unconstitutional that imposed a racial segregation in different respects. Okay? The cases we have today, though, are different. These are not laws involving state segregation. They involve a federal law that prohibits racial segregation. And specifically, we have the Civil Rights Act of 1964. Okay? Who's next, Nolan or Nick? I think. Yeah, Nolan. So tell me, what did the Civil Rights Act of 1964 do, among other things?
Didn't it just say that, that like businesses couldn't discriminate because of race?
What kind of businesses?
Restaurants, hotels.
Yeah, what do we call those types of businesses? There's a phrase for them.
Um,
All right, Nick?
Services? Serve the public?
There's a more specific phrase. Yeah.
Public accommodation.
Yeah, very good. They're places of public accommodation, right? They are places of public accommodation. You might have learned the phrase common carriers. That name sound a little familiar, maybe torts or contracts, right? What's a common carrier? Historically, at common law, certain businesses were given monopolies, right? So think of a railroad. Railroad in a place, it's very expensive to have multiple railroads, so the government says, you are the railroad. And if I walk up and I want to buy a ticket, they have to sell me a ticket. Whatever the rate is, they can't say no to me, right? Hotels, right? There might only be one hotel in a city, and that's what's licensed to be there by the state. If I want to spend a night there and I can pay their fee, I get a room, right? In the olden days, there might be one restaurant on a road, right? That's the restaurant there. If I walk in and I pay the fee, they have to give me dinner, whatever it happens to be, right? Congress, through the Civil Rights Act, said if you are one of these common carriers, one of these places of public accommodation, you cannot segregate on the basis of race. Or you cannot segregate your businesses on the basis of race. All right. So the question then was, did Congress have the power to enact this law? Right? They were not regulating the shipment of goods. They weren't even regulating businesses that ship goods interstate, right? These were local restaurants, hotels. Hotels fixed, right? It's not going anywhere, right? The Heart of Atlanta Motel is not going to travel, right? They're not going to ship rooms to other states, right? They're not going to, ship a local barbecue joint, ship ribs across state lines, right? This was local. So I'm sorry, do you have your name tag?
No, it's in my back.
Okay, what's your name?
Katie.
Katie. Okay, so let's walk through the first case, right? Heart of Atlanta Motel versus United States. What were the facts there?
The Heart of Atlanta Motel was operated in Georgia, had 216 rooms, was available to transient guests, and readily accessible between two interstate highways.
Okay.
They solicited customers outside of the state of Georgia, through national advertising media, billboards, and then 75% of the guests were from out of state. So prior to the act being enacted or enforced, they rejected Black people, and they alleged that they were going to continue to do so. So they filed a declaratory judgment action based on saying that Title II of the Civil Rights Act
Okay, very good. Thank you, Katie. This is a segregated hotel. Did anyone see the movie The Green Book, by the way? Anyone see this movie? It came out, I guess, in the last year. I didn't get a chance to see it, but I know the general gist of it. In the 1930s, 40s, and 50s, a group based in New York published this book called The Green Book. And the idea of the book was, if you were an African American and you were traveling to a city, what services could you use? What hotels could you use? What restaurants were not segregated? What gas stations? A barber shop, whatever it happened to be, right? What facilities were available? If you go to the Library of Congress website, you can see them. And I actually checked in Houston. There were some businesses you could use. You actually see addresses where there's still establishments, they still exist, and then what sort of businesses were open. The reason why this book existed was because a lot of facilities were simply not open to black customers, that you would not be allowed to use them. You walk in, you say, I want to pay for a tank of gas, and you couldn't do it, right? You say, I want a hotel room, they wouldn't give it to you. And one of these facilities was the Heart of Atlanta Motel. Okay, everyone with me? Now, the Heart of Atlanta Motel, again, was fixed. It was in one space. It didn't move across state lines. But they would not rent their rooms to African American customers. So Nahian, right? Okay, so Nahian, let me ask you this question. Why was Congress able to regulate or prohibit, I should say, the segregationist policy that was used in the Heart of Atlanta Motel?
Their reasoning was that it affected interstate commerce because if African Americans weren't allowed to stay at the hotel, then they were not paying and staying at that hotel, and it affected interstate traveling.
Okay, well, I want to piggyback on one thing you said at the end, right? So generally when we think of commerce, what do we think of, right? Moving between state lines, what's actually moving?
Like goods.
Merchandise, right? But how did the court here view the term commerce? What did they actually include in that category? It's kind of a little weird. What was actually moving from one state to another? It wasn't like merchandise. People. Everyone see that? It's kind of a weird thing, right? Where it describes the commerce between the states not as like widgets, but people traveling. And that Congress has the power to ensure the free flow of commerce from one state to another. So if I'm driving from New York to Florida and I need to make a pit stop in Georgia somewhere, in Atlanta, Congress has the power to prevent obstructions to the flow of that commerce. In that case, the commerce is actually people moving from one state to another. Now, I think this case is made easier by the fact that, in fact, this motel advertised out of state. They put in commercials, they attracted people, they put in billboards, et cetera. So they were directly appealing to sort of interstate commerce. But it's a weird thing to have people described as commerce. I don't know. It's always sort of non-intuitive. First. Yes, sir, Tanner.
So how come they just didn't apply the Equal Protection Clause?
Oh, what a good question. That's my next question, actually. Let's talk about Justice Douglas for a minute. Right? Let's talk about Justice Douglas. Now, Justice Douglas was, at this point, in the middle of his career, but he was the court's most unabashed progressive by far. Antoine, walk me through, please, Justice Douglas's concurring opinion, which I think might shed light on Tanner's question.
So Justice Douglas's opinion, he was concurring with the majority opinion, but he was reluctant to rest solely on the commerce clause, because obviously, it was mostly, he didn't want to think about people, black people, like commerce.
Yeah, exactly. So instead of looking at the Commerce Clause, the Necessary and Proper Clause, by the way, they don't mention Necessary and Proper Clause here either, but you know what's going on in the background. So Antoine, tell me, what provision of the Constitution would Justice Douglas look to instead of the Commerce Necessary and Proper Clause?
Section 5 of the 14th Amendment.
Okay, very good. Let me just pause you there for a minute, right? We will spend the second half of the semester on the 14th Amendment. We'll spend so much you'll be sick of it, right? But I want to give you a brief preview now. The 14th Amendment has 5 sections, right? Section 1 says that nor shall any state deny to any person within its jurisdiction the equal protection of the laws. Now, under modern doctrine, this provision means that the state cannot discriminate on the basis of race in most cases. There's some exceptions, we'll get there later, but generally the court says that the state cannot discriminate on the basis of race. Okay? What happens if a state is discriminating on the basis of race? Section 5 kicks in. Congress has the power to enforce Section 1 by legislation, by appropriate legislation. So if a state is not protecting people on the basis of their race, Congress can enact laws to, for example, create damages, right? You can sue the state for violating your rights, right? Congress can open up the federal courts to allow these sorts of cases. Now that sounds great, right? So Congress can enact laws to prohibit people being denied equal protection based on their race, but there's a problem. The word state. The Supreme Court held in a case from 1883, I might be off by a couple of years. The case was called the Civil Rights Cases. Very unoriginal name, I know. The Civil Rights Cases. And the Civil Rights Cases held that the 14th Amendment's Equal Protection Clause only restricts state action. The 14th Amendment's Equal Protection Clause only restricts state action. It does not allow Congress to regulate private business transactions. So if a private business is segregating, that is not for Congress to do anything about. The states can regulate private businesses, not the federal government. So the response to Justice Douglas's concurrence is you have to overrule the civil rights cases. He says, so be it, right? He didn't care. Douglas is probably right about this, but we'll get there later. As an original matter, it's not clear that there was such a state action doctrine. But we'll maybe talk about that a little bit later. But the upshot is the court killed Section 5, right? The court limited Congress's Section 5 powers. As a result of limiting the Section 5 powers, the court had to expand the scope of the commerce powers. I said again, because the civil rights cases read Section 5 very narrowly, the court then had to read very broadly the commerce and necessary and proper clauses. And that's what gets us to Heart of Atlanta Motel. Justice Douglas was only a concurrence because they had only the necessary and proper clause and the commerce clause to rely on. And they built upon the New Deal precedents. So today, almost all the federal civil rights laws we have are not premised on the 14th Amendment. They're premised on the commerce and necessary and proper clauses, which again is, I think Antoine said it well, it's a weird thing to think of people as commerce, right? It's almost like wait, what are you arguing? People are commerce, right? But that's the basis of most federal civil rights laws, precisely because of the narrow reading of Section 5 of the 14th Amendment. Okay, makes sense for Heart of Atlanta. Okay. Any other questions in Heart of Atlanta? Oh, yes, sir. So your name tag is? I'm sorry, I can say. Yeah, Kobe. Sorry.
So if the hotel has served local residents and not served transient people?
Well, that's the next case, right? Because that's Ollie's Barbecue. They didn't serve out-of-state customers, right? We'll get there in a minute, I promise, right? But everyone see the Heart of Atlanta case, right? Oops. So questions on Heart of Atlanta? And by the way, the hotel's still there. If you're ever in Atlanta, it's now Hilton right now. It's a huge hotel, but the facility is still there. Okay. Okay. I actually forgot it. This is in the book, so it's not a surprise, but I have a lot of eBay alerts for all the various cases. I always find like little trinkets. So I actually have a case of the barbecue sauce in there. I've never actually tried it. I don't know if you like barbecue sauce, but I have a case of it. And also I found a matchbook from Ollie's Barbecue. And the funniest part is the matchbook was made in Atlanta, and the barbecue's in Alabama. So I have proof that they actually had stuff from out of state. Well, I solved the case, whatever it's worth. I was actually so excited when I figured that out. But yeah, that's what I do. All right, but let's go back to our timeline, right? We have Heart of Atlanta, and I don't think Heart of Atlanta really went beyond Wickard, right? I don't think it had to. It effectively said these local activities in substantial, this local hotel does all this business out of state, so this hotel by itself, has an effect on interstate commerce. No big deal. But the next case, Katzenbach, was a little bit harder, right? Yeah. Oh boy. Okay. Okay. You have your name? Take it home.
Yeah, Susan?
You have your name? Take it home.
Yes.
Okay. It's next class. Okay, Martin. Martin, why was Katzenbach v. McClung a tougher case than Heart of Atlanta? It was a harder case for sure.
Was it more just because it was really focused on interstate commerce, more just interstate? Just
Well, what was the big difference between the Heart of Atlanta Motel and Ollie's Barbecue? What was the big difference in the facts between the Heart of Atlanta Motel and the and Ollie's Barbecue?
that it bought majority of its food from outside?
Well, did the Heart of Atlanta Motel service customers out of state?
Yes.
Okay. Did Ollie's Barbecue service customers out of state?
No.
Okay, that's the big difference, right? Heart of Atlanta Motel is actually, under existing doctrine, an easy case. You literally had people driving from out of state to go there. So there wasn't much of a problem. But Birmingham and Ollie's Barbecue is different. Here they were only serving local customers, right? They were only serving local patrons at their restaurant. It was a segregated restaurant, but they only served locals. So you couldn't claim that they were advertising out of state. You couldn't claim that they were attracting business from out of state. People weren't driving from New York to go get a barbecue there. It wasn't happening. Maybe there were some customers from out of state, but there's really nothing in the record to support it. So instead, the court takes a different approach. Ruben, how does the court resolve Katzenbach? And they have to, if you see, they sort of expand the doctrine a little bit more beyond the Atlanta case.
I think you said it earlier, it's the exchange of food in between the states.
Very good, very good. Right. The court creates a concept which became known as a jurisdictional hook. A hook. What does that mean? Because the restaurant uses goods that travel in interstate commerce, Congress can regulate that business. Right? Their food came from out of state. Their vegetables came from out of state. Their appliances, think of the ovens and the grills, came from out of state. The oil used for the cooking came from out of state. Right? Whatever any business uses, some of it came from out of state. And because some of the goods came from out of state, Congress can then regulate those out-of-state goods. Right? Even if the restaurant is intrastate, by the way, just make sure we get your terminology correct, right? You have interstate and intrastate. Interstate means between states. Intrastate means within a state, right? Even if the restaurant is only intrastate, goods move from one state to another. And once you have these goods that moved into interstate commerce, Congress then can regulate it. Randy likes this phrase. I think it's kind of gross, but it's been called the herpes theory of federal power. Because once it touches interstate commerce, it's forever tainted. You're welcome. Randy put this in the video. I wasn't keen on it, but he put this in the video, so there you go. So the herpes theory of federal power. Once it touches interstate commerce, it's forever tainted. God, Lord help us, right? But is that Jessica?
Yes.
Jessica, let me ask you this question, please. What then is the limit, right? What we know from NLRB versus Jones and Laughlin Steel that there's some distinction, right? You can't obliterate the distinction between what's federal and what's local, right? What's the limit then? What can Congress then not do? I see you're struggling a bit. Does the court here maintain that there's any limit about what Congress can't do? About the limits on Congress's powers? No, they do not. No, they do not. At least in NLRB versus Jones and Laughlin Steel, they said, well, there's some limit, we just won't tell you what it is. By the time you get to the 1960s with Heart of Atlanta and Katzenbach, the court basically suggests that there is no limit, right? And for the period between 1960, was it 64, and the 1990s, you would not have a single decision that imposes any limits on federal power. If you attended law school during that period, you were basically taught that Congress can do whatever it wants and there is no limiting principle at all. In our next class, we'll see why that's not exactly the case, or at least the court manufactures some limits, perhaps to be more neutral. But I want you to think about this limit, right? In order to enact a law like the Civil Rights Act, which I think we all agree it's a good idea as a general matter, you need to have this broad conception of federal power. That same broad conception of federal power in Prigg led to the Fugitive Slave Act, right? So it's not always universally a good idea to give Congress this sort of power, right? The same power over the same implied power that led to the Fugitive Slave Act, which we think is bad, I think, can be used to create something good, which is the Civil Rights Act. So there's not, federal power is neither good nor bad. It depends on who's using it, and depending what kind of laws they're appropriating. So when I ask you to think about this, don't think only, oh God, yes, Civil Rights Act is good, Slave Act is bad, right? Try to actually consider the general scope of what powers Congress should have versus the states. And it's not always such an easy, straightforward question. All right, questions on that? All right, let me talk a bit about the exam while I have you here at a few extra minutes. If you go back to the syllabus, I link to all of my old exams. Now I'll address this point. We have a grading policy at South Texas, which basically says for a first-year class like ConLaw, your grade is 100% of your final exam. That's a policy. I cannot give you a graded midterm. I'm not allowed to. Your grade is your final exam. For the past maybe 4 or 5 years, I had given a midterm in the middle, and I graded it, but it didn't actually count. My experiences with it were not very good. Most students, didn't take it seriously. The second they heard, oh yeah, it doesn't count, they blew it off. Most students, they didn't study. They didn't actually have an outline ready at that point. And they didn't really care. A lot of students, actually at the time, I made it mandatory to meet with me. All 100, however many were, they all came to meet with me. I was usually here for 12 hours a day. And I said, how did you study? He said, oh, I looked over my notes, which is not studying at all. So I basically told the dean that I am not giving a midterm again that's graded until I can actually count it, which perhaps sucks for you. But what I will do is if you want to take one, I will grade it for you on my own, right? In other words, I won't do it as a formal thing, but if you take one on your own and you come to me, I will grade it and I'll tell you how you did. That's my compromise. So for the students who actually care, I will give you the same sort of attention. And for the students who don't care, that's on you. I encourage you to take me up on it. I truly do. Because the easiest predictor for your final exam performance is by taking sample exams. Generally, whatever score people got in the midterm was their final exam score. There was very little deviation. It didn't fluctuate much. Okay? I want to walk you through last year's final exam. By the way, I have a couple links. You have the final exam. I have the A+ answer plus a memo. I'll just walk you through the one from last summer just to give you a sense of what it looks like. 3 hours, normal. There's a word count, a strict word count. There are 2 questions. Each question is a 1,000 word limit. Now, Josh, why do you have a word limit? Let me explain my thinking here. It's what makes the answer fair. There are a lot of you, I know who you are, who can sit here and they can dump 5,000 words in an hour. I know who you are. I did the same thing, right? They just brain vomit over the paper, hoping, praying that they touch enough bases to get points. Not going to work here. You actually have to pick and choose your words carefully. I want you to answer the question directly. I don't need you to vomit your entire outline on the page praying that you get points. That's not going to work in my class. I know you do it. It's not going to work here. So there are 2 questions, each of the 1,000 word limit. That's 1,000 words, not 1,000 characters, right? Every year there's one person who gets scared, they get intimidated, and they're at 1,000 characters. That's like 5 text messages, okay? You're laughing. One of you will do it, I promise. It boggles my mind. They panic, like, oh my God, 1,000 words. It's like 4 or 5 sentences, right? I mean, it's just, I know it. I just feel bad for that person, but like I'm warning you, so you're on notice. Please type. I don't want you to handwrite it. It's not in your advantage. When you have an exam with a word limit, you have to move stuff around, edit, re-edit. If you do it by hand, you're putting yourself at a handicap. You will all take the bar in a couple years. Learn to type. If you haven't already, learn to type. This is a good practice, right? But you should all be ready to type your bar exams. There's no reason to handwrite your bar exam. I don't know why you would do that, but it happens. I remember when I took the bar, one of my friends realized she forgot her charger at home, and the exam was in Roanoke, Virginia, not like in a city. There was no Apple store that existed, and she had to handwrite it because she forgot her charger. Right? She was actually asking, "Hey, can I borrow your charger?" I'm like, "I'm sorry, no." It's like an 8-hour exam. You bring your chargers. I think I told her to put an ad on Craigslist for to pay like $500 for a charger if anyone would bring it to this test center, but it was risky anyway. So the exam, please, for the love of God, type. Don't handwrite. Every year, once people handwrite, I can't stop you, but it's your advantage. The exam will have 2 parts. The first part is what I call the historical question. I will set you at a point in the past. I'll say the year. In this case, let me make it bigger. It's hard to read. I'm sorry. This one, the year was 1956, and this was a case about the segregation cases, right? The limitation here is to test you at how the law existed at a specific point in time, right? I'm not interested in how it exists today, right? Law develops, goes up and down, left and right. I want to know how the law existed at that point in time, which means you are not citing cases that came afterwards. That's the easiest way for me to take points off. I know it. I can tell it really quickly. This is why when you have your outline, I forgot to mention it earlier, but when you have your outline, you got to put the years. You need to know this. We have this timeline in the video. This will help you a bit with the enumerated powers cases, but you have to think about this in sort of a sequential fashion. If you notice, the book is largely chronological. It's not entirely, we jump around a little bit, but it's more or less in order, which should help you with your studies. Usually the call is like, your law clerk for the Chief Justice, but I can do it differently. I can say you are, the legal advisor to the president, right? Or you're the legal advisor to the governor, or you're the legal advisor to a member of Congress. Not all the questions are asking about the courts. Some of them say, what should the president do, right? Not what the court will do, what should the president do? I've asked questions in the past where the year is 1789. The Constitution hasn't been ratified yet. There is no Supreme Court, right? I think I had one exam, the year was 1776. We don't have a Constitution yet. We're still fighting a war. So you cannot marry yourself to the Supreme Court. It will not always help you, okay, for the historical question. The formats are always the same. There are 5 parts. Each part, so for example, part 1 has 5 questions, right? Question 1, 2, 3, 4, 5, right? Unsurprisingly, there are 5 questions for part 1 for 50%. Each question is graded on a scale of 1 to 10, right? Makes it very easy. So if you get 10, 10, 10, 10, 10, you get 50 points. I've never had a perfect 50. It hasn't happened yet, but maybe it'll happen one day. Maybe you'll do it. What's a 10? What's a 1? as a general matter, I like to see a few things. I like to see that you understand the cases. It's not enough to say, oh yeah, Gibbons v. Ogden. It's you're taking the facts of the case and telling me what the answer is of my question. The way I write these exams is I'll take facts you're familiar with and I'll sort of twist them around. I'll shift them around. You have to spot the issues, right? Say, well, this case is similar to Gibbons because of X, or that case is different from Wickard because of Y, right? The person who actually spots how a case is similar to or different from a case you studied, that's the 10, right? That's the 9. I want to see that you actually understand the cases so well. You're not just saying Gibbons v. Ogden held blank, right? Anyone can do that's like a 7 or an 8, right? But by giving me a 9 or a 10, it's saying Gibbons held this, but we're a different situation because of whatever. Also, people don't like the word policy. I don't like it much either. But there's some policy issues that factor into it. You know, does the court favor deference or restraint? Does the court favor a broader federal power or a more narrow federal power? Right? These are sorts of policy questions that sort of pop up over and over again. Or my favorite, you know, why do people follow courts? Right? These sorts of issues. Work that in. That gets you closer to a 10. Usually, the 5th one in any exam, question number 5, is always a policy question expressly, right? This one, how do courts ensure that parties comply with their judgments, right? We haven't done that yet, but it's not a legal question, it's a policy question. So you have a very strong policy one at the end, so I see that you're actually paying attention. The policy ones reflect what we talk about in class. If you just do the readings, you'll be fine, but the class discussions really give you part 5. Okay, so again, part 1, there are 5 parts, 1,000 words. It's not 1,000 words per, it's 200, 200, 200, 200, 200. Keeping it roughly equals usually a good measure. Part 2, also 50%. The difference is you're now in the year 2019. We in the present, so you have all the case law to discuss. So in some regards, it's easier because you don't have to like limit yourself, but then you have to think about, oh my God, there's everything, right? All this other law. So the historical questions have strengths and weaknesses. On the syllabus, I have a lot of old exams. Again, I have my midterm from fall 2018. If you want to take this, have me take a look at it. I would suggest that one. That was from like last year. Office hours are open. Come on by. I'd be happy to talk to you. Just print it out. Come by. We'll chat. Okay. I want to meet with you. I enjoy meeting with students, but just people didn't take it seriously, and unfortunately, you're paying the price for the sins of your predecessors. But that's how law school works, unfortunately. Yes, Braden.
You say that it's going to be open book.
Oh yeah, completely open book.
Can you explain like only this book?
Whatever you want.
So I can bring my own notes?
Bring your own outline, doesn't matter. It will not help you. Yeah, let me address that. Well, first off, you have to have it printed. You can't bring your tablet. You can't bring your notes on your iPad. Unfortunately, that's just I did a poll on this a couple of years ago because someone said, "Can I bring my notes on my iPad?" It's too hard to eliminate cheating. There's no way. People have hotspots, right? There's just no way to prevent you from cheating if I give you your iPad. So just kill trees. I'm sorry. You got to print it out, but you can print out whatever you want. But let me tell you something. It's not going to help you. The exam's 3 hours. You will be working to the last minute, right? If you spend 5 minutes flipping through your outline, you're wasting time, right? The more you spend flipping through your notes, you're going to run out of time. People don't finish every year. You can finish it if your notes are in good shape. As a general matter, when you prepare your outline for class, your outline from home, it's going to be a long process, right? It's going to be a long document. As the semester goes forward, you should be refining it and shortening it and distilling it to just the stuff you need. And if you go look at, go talk to the Langdell. His name is Tim. He's actually he's an AP government teacher. He's a very, very smart guy. So he's a good teacher. But if you look at his notes, by the end, it was maybe 20, 30 pages long. I mean, it's a short document, right? You probably have 30 pages already. But it's a short document with, basically the name of the case, the year, and some short fact blurb about it with the holding, right? It should be in your head. Any professor who makes a book closed book, they are trying to test a different skill set, right? And it's an important skill set, but for mine, your notes aren't going to help you, right? So you can bring that 1,800-page book, you can bring, whatever outline you want, always, in the Constitution, they should always be in your pocket somewhere nearby, but the notes aren't going to help you. If you find yourself looking at your notes too much, you're going to run out of time. Another reason why the practice test is important is you can time yourself, right? Go to the library, take it in 90 minutes, see if you finish. You may not finish. Like, oh my God, what am I doing wrong? Right? If you're flipping through your notes, and you're going to kill yourself. Run out of time. Okay. A few other points on the exam, then I'll let you go. You have to be very careful as you prepare for this class. We have a lot of material. As you probably have noticed, the readings are heavier. And right now, I've only taught you maybe about a dozen cases. We'll have about 100 cases by the end of this term, and you need to know basically all of them, right? Maybe not the exact year, but the general decade. And maybe you may forget the name of the case, but you have to say, oh, that's the case with the chickens, and that's the case with the wheat, right? Then you can check your notes. But you need to at least know all the cases, because no matter what I ask you, you're going to have to bring it back to some sort of doctrine you've studied. Yes, sorry, your name tag fell over.
Yeah, sorry. Took it over.
Yeah, Amy, yeah.
Took it over, Amy.
Yeah.
So when we are referencing cases in our form, you say that we don't need to have the exact name.
Well, in your exam, you should.
Oh.
Right, I'm saying in your own head, if you say, oh, that was the chicken case, then you check your notes. What was the chicken case about, right? Or that was the case with the wheat, then you say, oh, that was Wickard. But you have to use the case name. Okay. Right, if you say the chicken case, I mean, that's nice, but that's not the name of the case, right? I mean, I know what you're talking about because I've done this 100 times, but give me the name of the case, please. Okay. Anything else? Going once? Twice? Oh, yeah, Natalia. Just at the end, yeah.
When would you recommend to take the practice midterm?
Yeah, that's a good point. I would say, so let me just show you the calendar of the semester, and I'll give you the exact date when I think you're ready for it. It's roughly the halfway point. I would say after class, maybe after class 13 or 14, so roughly halfway through the semester, so by the beginning of October, middle of October. And let me put it this way, even if you're not going to be perfect, you may not know everything, you'll know enough to give yourself a gut check, but I think by class 13 or 14, give or take, I think you're in the ballpark. It's not perfect, but that should help you out. Maybe class 15, but sooner is better than later, right? Because I have other midterms that you can also look at if you take that one. Okay. Anything else? All right, have a wonderful day. I will see you all on Thursday, and I'll be up in my office for the next hour if you need anything. I have class in another hour, but I'll be there for an hour.